The government shares the Noble Lady's goal to protect vulnerable people from harm, and it remains our intention to publish a draft bill for pre-legislative scrutiny. However, I must express reservations about this bill and raise concerns relating to 4 areas: the definition of conversion therapy, the inclusion of suppression within the offence, the use and lack of definition of gender identity, and the proposed territorial extent of the bill. Firstly, in terms of the terminology and definition, the government now uses the term conversion practices to reflect the fact that conversion acts take a range of different forms and to avoid conflation with legitimate talking therapies. Furthermore, I'm also concerned that the definition is very wide in scope, appears to lack precision and clarity, and therefore leaves it vulnerable to misapplication. And it's vital that any legislation targeting these harmful practices does not affect the ability of parents, teachers, counsellors, religious leaders, or healthcare practitioners to have open, exploratory, and sometimes even challenging conversations, particularly with young people who are expressing or exploring their sexual orientation and/or their gender identity. In particular, I worry that such a broad definition would create a chilling effect for those working in the legitimate clinical care sector who may feel too nervous to conduct their jobs out of fear of potential criminalisation. This in turn could negatively impact those people who are seeking and indeed needing support in relation to feelings of gender distress, gender dysphoria, or indeed in coming to terms with their sexual orientation. I must also express reservations around the inclusion of suppression within the scope of the offence. This risks a very wide range of acts being criminalised and is likely to disproportionately impact freedom of thought, conscience, and religion. Moving on to the use of the term gender identity, whilst we agree that any protections should include all those at risk, whether straight or gay, transgender or not, the government has significant reservations about relying on the term gender identity. This is not a recognised term within our existing legal framework and is a contested belief. Introducing it in this way risks a lack of legislative clarity, which would likely make prosecutions difficult and set an unhelpful legislative precedent, which could have much wider ramifications in both criminal and civil law. Finally, the bill proposes to legislate for the whole of the UK. This would be problematic because, of course, criminal justice is fully devolved to our Scottish and Northern Irish counterparts.